Magandang araw mga kababayan, ito po ang inyong kabisang Chris Aranda dito po sa ating live broadcast recorded earlier sa Ustream at mapapanood po natin sa ating Facebook account sa Immigrant Visa Center at sa Amerika at iba pa. Ang atin po pag-uusapan, yung petitioner passed away, what happens to the petition? Why this topic? Because in all the questions that were sent to us nitong nakaraang live broadcast, a lot of them were asking about the fact that the petitioner has passed away or the petitioner is still domiciled, already domiciled in the Philippines, dito na nakatira at dito na rin sumakabilang buhay. So they are asking, what happens to my petition? Can I still proceed with the petition? Okay. But before we discuss that, unahin po natin ang priority dates for February because it's the first week of January. But we already have the February dates para sa inyo. So for February of 2015, ito po yung sa F1. F1 would be for the over 21 unmarried sons and daughters of US citizens, and the petitions being processed or being issued visas are those that were filed January 8 of 2005. So that's for the F1. For the F2A, this would be for the spouses and children of green card holders. The petitions being scheduled for interview at the US Embassy through the NVC would be those petitions filed May 8 of 2013. For the F2B, this would be the over 21 unmarried sons and daughters of green card holders. Petitions filed on or before 22nd of February 2004 are being issued their visas or being scheduled for interview. For the F3, petitions filed on or before July 15 of 1993. And for the F4 category, the brothers and sisters of US citizens, August 8 of 1991. The good news for employment-based categories, all the employment-based categories from EB1, EB2, EB4, and EB5 are current. Only the EB3 remains backlogged or retrogressed. But the good news is now for February of 2015, the priority date being processed with petitions filed January 1st of 2014. So, kung namatay naman yung employer, yung essentially ano yung namatay? If the employer became bankrupt or goes out of business, nawala na kayo ng employer. If the employer who sponsored you has gone kaput, nawala na siya, another employer can take over your petition. However, that new employer must file a new I-140 petition for you. But the good news is your new employer who filed the petition will be able to get the same priority date. So if your priority date is on or before January 1st of 2014 or even later than that, it is good that your employer, if you got a new employer, must file a new I-140 petition so that it will take about another 2 to 3 months for it to be approved. Then you'll be able to go to the United States even if the old employer has passed away. For the family-based petition where the employer has passed away or has been domiciled or residing in the Philippines, then hindi kayo pwede mabigyan ng visa kung naandito sa Pilipinas. Maganda kung buhay pa because if they're still alive, you can argue or the petitioner can say that, well, I've waited for my son or daughter to be, for the visa to be current and now we're going back to the United States together. But if the petitioner has passed away, there's still a way. The visa beneficiary or the person being petitioned can request for humanitarian consideration or reinstatement of the petition based on humanitarian concerns. To be able to get that humanitarian consideration, the visa beneficiary or the person being sponsored must prove that he or she still has a relative in the US. A qualified relative would be a spouse, a parent, a son, a daughter, or a sibling, brother or sister in the United States. The second part is that the qualified relative in the United States must be able to prove that he or she would suffer extreme hardship if the person applying for the visa will not be granted the immigrant visa. So those are the factors. How do you apply for it? If your priority date is current and you already have an interview date sa embassy, then go ahead, take the medical exam. In the medical examination, there's a form that will ask you, is the petitioner still alive? So you should answer yes or no if the petitioner has passed away or not. At the consular level, during the interview, if you're asked about the petitioner, you must admit that the petitioner has passed away. Otherwise, you can be charged with misrepresentation if you say that the petitioner is still alive, and then they ask for the petitioner's proof of life. Then you will not be able to present it. Then you can be denied your visa application or denied your visa, not because the petitioner has passed away, but because you committed misrepresentation, and that is permanent. So you must be able to prove that you're eligible for the humanitarian consideration. So if you're at the embassy level, your petition will be returned to the NVC. The NVC will return it to the USCIS. The USCIS will inform you that you can apply for humanitarian consideration. You submit your application for reinstatement of the petition, and you wait maybe about 3 to 6 months. If it is granted, then you will be able to get the visa. If your children have turned 21 and they're no longer eligible for the case that you have, then you may want to look at the CSPA or Child Status Protection Act formula, whether they would still be eligible. However, that issue is the topic of another live broadcast. If you want us to discuss a topic here during our live broadcast, please text your concern to 0917-534-8472. I will repeat. You can call or text our number 0917-534-8472, or you can send your resume to cra@visacenter.org, so that if you're no longer eligible for the US, we shall be able to get you an assessment. You might be eligible for migration to other countries such as Australia, Canada, New Zealand, or the UK. Until the next live broadcast, this is Chris Aranda. Ito pong inyong kabisang Chris nagsasabing hasta la vista, baby.